Good afternoon, my name is Megan Kilmer and I will be presenting the case United States v. Oceanic and the court's approach to criminal vicarious liability when employees are found guilty for criminal actions when acting in the scope of their agency and employment, but also benefiting at least in part the principal. In doing so, I argue that the court's application of criminal vicarious liability was unduly harsh and did not adhere to the legislative intent of APS. This case concerns the MV Ocean Hope, which is owned and operated by Oceanic and Ocean Fleet, which is a vessel that was designed to transport cargo across the globe in a safe and timely manner. However, during its voyage from Bangladesh to North Carolina, they fell short of this mission when it was found that they systematically discharged thousands of gallons of oily pollutants into the ocean. During this operation or voyage, two of the Energy Department engineers, Chief Engineer Ignacio and Second Engineer Sampson, violated the protocol set forth by MARPOL and APS by releasing these oil pollutants, also falsifying the oil record book. When they arrived in port in North Carolina, the United States Coast Guard boarded the vessel for a routine inspection. During this time, both Ignacio and Sampson instructed their crew members to lie to the Coast Guard about the oily pollutants. But working off of a tip, the United States became privy to this knowledge, which led to the prosecution of Ignacio and Sampson along with Oceanic and Ocean Fleet. So under MARPOLs and APS, civil and criminal penalties are available for those who violate these regulations. In this case, criminal penalties were doled out for offenses committed by both Ignacio and Sampson, which included conspiracy, failure to fully and accurately maintain their ORB, obstruction of justice, among other charges. Additionally, these penalties can extend to the corporation under the theory of respondent superior. In this case, both Ocean Fleet and Oceanic received penalties collectively in fines upwards of $2 million, along with a 5-year probationary period and a ban of all U.S. ports until their financial aspect is fulfilled on their part. At this time, I'd like to discuss some of the court's holding and reasoning why the court decided to hold both Oceanic and Ocean Fleet vicariously liable for the actions of their employees. First, the court looked to whether there was an employer-employee relationship between Ignacio Sampson and Ocean Fleet and Oceanic. They did this by examining the prosecution's evidence. Specifically, they looked at the Ocean Fleet manual that was given to every crew member on the vessel. These highlighted some of the duties and responsibilities of both Ignacio and Sampson that they were expected to fulfill during their time on the vessel. Additionally, they noted that there was employee contracts between Ignacio and Sampson, Ocean Fleet and Oceanic, along with paychecks that were given by these two corporations to the two employees for their time. Also, the uniforms that the two employees wore had the representation logo from those corporations, along with the fact that both of these employees were expected to give daily updates on their ORBs to both of these corporations. So the court held in reviewing this evidence that there was sufficient evidence to hold that there was a proper employee-employer relationship. Second, the court analyzed whether the actions of Ignacio and Sampson were within the scope of their employment. Again, the court looked to the Ocean Fleet manual and the detailed duties that were set out by them and found that both Ignacio and Sampson technically were still in their scope of employment as engineers by releasing those pollutants. Also, the court noted again that these daily ORB updates that Ignacio and Sampson were giving the corporations should have put the corporations on notice that there were some falsifications that Sampson and Ignacio were putting in there. Lastly, the court looked to whether the actions by Ignacio and Sampson were benefiting the parent company. In doing so, the court turned to their previous holding in United States v. Singh and applied the legal proposition that they did in that case, where it states as long as the corporate agent intends, at least in part, to benefit his employer, the corporate entity can be criminally liable, even if the agent is also acting for his own benefit. So at this point, I just want to pause for a second and go over the facts of United States v. Singh. This case involves an interstate prostitution scheme that involved 2 employees and 1 employer. It occurred over a duration of a 3-year period and rendered monetary profits of over $670,000 that were split in between the employees and employer. Those 3 individuals were indicted on 14 offenses, but the employer was also held criminally vicariously liable for the actions of his employees, mainly because he had direct knowledge of the actions of his employees. So in this case, while the Fourth Circuit was likely correct to apply the legal proposition of Singh to this case, the court neglected to take into account the severity of the circumstances set forth in Singh in comparison to this case for 3 reasons. First, the duration of the offenses that occurred in Singh were far more frequent and for a greater duration than this case. This case the court was only looking at a single instance with a single voyage. Second, Oceanic and Ocean Fleet did not receive any direct or recognizable monetary profit by the actions of Ignacio and Sampson, whereas Singh, the employer, was receiving substantial monetary profits. And lastly, unlike Singh, Oceanic and Ocean Fleet were unaware of the illegal actions of their employees, whereas in Singh, he had direct knowledge of doing so. But based on these comparisons or lack thereof, it's clear that Singh correctly held that the employer was criminally liable for the actions of his employees for appropriate reasons, whereas here the court failed to take into account the severity required to hold criminal offenses for the corporations. So in light of this analysis, it should be further questioned whether corporate criminal liability is appropriate based on the intent behind the Act's enactment of MARPOL. MARPOL focuses on sending a message of deterrence to all parties rather than simply holding or handing down criminal punishments for any violation. So in this case, one can make the argument that the court should have addressed the question of whether holding Oceanic and Ocean Fleet civilly liable for the actions of their employees is a more appropriate and effective deterrent than simply handing down the corporations with criminal liability with significant punishments. The answer to this question may be that the court should only apply criminal liability when it's socially desirable. This occurs when detection and prosecution are difficult, when sanctions on corporations need to be extremely high in order to maintain deterrence of this behavior, and when there are a large number of false convictions compared to false acquittals that cannot be efficiently remedied other than through the protections of criminal procedure. So applying this analysis to the circumstances of this case, it becomes clear that although corporate liability was optimal, detection and prosecution was not difficult, and the sanctions did not need to be excessive in order to send a proper deterrence message. Additionally, there wasn't any evidence to support that these large sanctions will deter these types of actions in the future, nor was there evidence to support the necessity for the protections of criminal procedures in this case. Since the facts of the case failed to fulfill this analysis, the court should reconsider holding Oceanic and Ocean Fleet vicariously criminally liable for the actions of their employees in order to coincide with the legislative intent of acts. Thank you.